So good evening, everybody. I think that we can begin now because we will have to finish right at the end of the panel because one of the panelists have to catch a plane tonight. So I would like to thank you very much for joining us on this panel. This is the last panel of the second day, so thank you very much for, keeping up until the last minute and joining us for this very interesting panel. My name is Elise Lassu, and I work as a researcher in the EU Agency for Fundamental Rights. And the panel that I would like to moderate today will be discussing the use of new technologies of our high tech by law enforcement and the impact on data protection and fundamental rights. What are we talking when we talk about new technologies, about high tech? This is voluntarily a very broad term. It can cover many different types of new technologies or technologies. I'm not sure they're still new today. So we're talking about drones, we're talking about predictive policing, we're talking about facial recognition, we're talking about emotion detection systems. Of course, we're talking about AI systems. So these are very different types of technologies, but they have two features in common. First of all, they use and they need personal data. So they are processing personal data, and for some of these technologies, very high-scale, very large-scale personal data. And the second one is that the impact of the use of these technologies goes well beyond data protection and privacy. At the EU Agency for Fundamental Rights, we conducted a number of research on predictive policing, on AI, on facial recognition, and we have evidenced that the impact on individuals can be on so many different fundamental rights, from, of course, non-discrimination, good administration, access to justice, freedom of assembly, and I can go on. So on this, the legislation, the legal system on data protection can help if it's properly implemented. I would like here to recall the exact name of the Law Enforcement Directive. It's not a directive on the protection of personal data. It's a directive on the protection of natural persons with regard to the processing of personal data. And I think this is very important to recall that here we're protecting natural persons, we're protecting individuals and all its fundamental rights. So in this context, in the context of law enforcement, I invited this amazing pool of experts that I gathered for this panel to reflect on two questions. The first one is, does the Law Enforcement Directive provide enough safeguards to protect individuals from unnecessary or disproportionate interference with their fundamental rights? And the second one relates to the enforcement of the Law Enforcement Directive. What are the main challenges to the effective implementation of the Law Enforcement Directive and how to overcome these? So to discuss this question, I'm very happy to welcome four experts on the topic of law enforcement and new technologies. First, we will begin with Griff Ferris. Griff leads the Fair Trials work on the use of algorithmic systems and new technologies in policing and in criminal justice. Previously, he was a legal and policy officers at Big Brother Watch, where he investigated and challenged oppressive and discriminatory use of technology and data by the state, the police, and private company. He has also worked as a paralegal and taken on cases from the Free Representation Unit and Lambeth Law Center. Griff will be talking about the impact of these technologies on individuals. So he will be giving us this perspective on the impact of individuals, on individuals. Then Anna Moshibroda is joining us from the European Commission. Anna works in the Directorate General for Justice and Consumers, DG Just of the European Commission, where she leads a team dealing with data protection in law enforcement. Her areas of expertise also include the data protection aspects of migration policies, and notably on questions related to asylum, the Schengen acquis, and large-scale IT systems. Our next speaker close to me is Julia Balazs. Julia is the DPO for the Danish National Police, police districts, and the PIU, so Passenger Information Unit. Her areas of responsibility include National Cybercrime Center, police big data analysis tools, data protection by design with regard to large IT projects, and international cooperation. And last but not least, our last speaker will be Juraj Seifert. Juraj is in charge of a research project making transparent invisible surveillance, digital investigatory measures in the European Union and their compatibility with EU data protection law at the Universiteit of Brussels, VUB. Previously, he worked for the Data Protection Unit of DG Justice and Consumers at the European Commission, moving from the position of a case processing lawyer at the European Court of Human Rights. I will stop here because for this panel, what I would like to encourage you to do is to think about the question that you would like to engage with our panelists. So because we have such a diversified panel, I have asked all of the panelists to take the time to really dive into the presentation that they would like to make. I would like not to then have a discussion from my side, but really to invite you to have questions, provocative questions if you want to, so that, you know, for this last panel we can have a very live discussion. And on this note, I will give the floor to our first panelist, Griff, please. Thank you.
Hi, everyone. I'm just standing up, so I'm not talking from my lap down there. So yeah, as with many areas of our lives, technological advancements have changed how law enforcement and criminal justice authorities operate. Automated systems, algorithmic systems, machine learning tools, often classified as artificial intelligence. They're being used by policing, by criminal justice authorities. And the disproportionate and invasive surveillance and data capture in many of these tools is having a very serious impact on people and their lives. And these authorities are seeing these systems as the opportunity to allow and justify the collection and seizure of huge amounts of information and then analyzing it using these more advanced systems. And a class of systems that Fair Trials and, of course, many others are concerned about are these predictive justice systems, systems used by police, prosecutorial authorities, probation authorities to profile people, to predict their future behavior, and assess their risk of certain future prescribed actions, sometimes linked to criminality, but more often than not, just linked to undesirable social behaviors. And those predictions, profiles, and risk assessments are used to influence, inform, or result in policing and criminal justice outcomes, including surveillance and monitoring, stop and search, fines, questioning, arrest, bail, prosecution, sentencing, the full range of criminal justice, very serious criminal justice action. They can also lead to non-criminal justice punishments, such as the denial of welfare or other essential services, and sometimes even the removal of children from their families. So in our research, and as indeed many others have found too, we found that these systems currently being used within criminal justice in Europe are further fueling and legitimizing racial and ethnic profiling and discrimination. They're normalizing preemptive law enforcement action and criminal justice action, and they're infringing data protection rights as well as other fundamental rights, including the right to a fair trial, the right to liberty, the right to a private and family life. Many of you, I'm sure, will have heard of these issues before, but until something is done to address these underlying issues and to address the impact that they're having, they need to be repeated. So in order to try and give life to it, I'm going to go over a few examples. So to start with, a system called the Top 600 is being used by the Amsterdam municipality in partnership with police and social services. It's automated risk modeling and profiling system that's been used since 2012, and it attempts to profile young people, or the top 600 young people over the age of 16 who it considers are most at risk of committing a crime in future. The criteria used by this top 600 risk profiling system is chosen by the police, prosecution authorities, and the Amsterdam municipality, and it includes whether someone has been arrested as a suspect for certain crimes, whether they've been a suspect in a crime within the last 2 years, whether they've presented to a bankruptcy judge. The use of this arrest and suspicion data and reports, as well as information about people's financial information situation as part of this risk model, which ultimately has criminal justice implications, is obviously extremely concerning. Now, another sister system called the Top 400, also used in the same area by the same authorities, is targeted at under 16-year-olds. And it also profiles these children on the basis of whether they've been arrested as a suspect for certain crimes, whether they're associated with alleged gang activity, so there's a clear racialized element, whether they've been absent from school or changed schools regularly, so they're using education data, and whether they've previously been subjected to police surveillance. Now, at least a third, and as many as half of the young men profiled, the young children, in many cases, profiled by these systems, have Moroccan Dutch heritage. So there's also a clear discriminatory element. The impact of these systems is very real, and here are some first-hand accounts from a lawyer working with some of these young men and children who have been profiled. Jesse has never been convicted by a judge of a street robbery, but because he's on this list, he's arrested whenever someone is wanted for a street robbery. Then it usually turns out after just one day that it wasn't Jesse. The thing is that arrests also count to get or stay on the list. And in this way, Jesse never gets off the top 600. Souf gets a ticket every 3 meters when he rides on his moped, simply because he's on that list. When he got himself a job, it was ruined by the top 600 because the authorities called his new employer to let them know who he was and that he was on the list, and he lost the job. A mother of sons profiled by the top 600 has described the significant impact it had on both her and her sons' lives. Diana Sarjo said that as a result of her sons being profiled by these systems, they were continually monitored and harassed by police. One was repeatedly accused of criminal activity along with the young boys he hung out with. Another time, she had to deal with police coming into her home. Stolen property had been tracked to the housing block where they lived, and the police came for her son again. At that point, they also took away her other 15-year-old son. Both were later released. When there was an assault and robbery in the neighborhood, the police again came for her son. She described being called to pick up her son from the police detention center late at night after he'd been taken there by police. She said that as a result, her children withdrew further and further. She's also said that other mothers of children profiled by the top 600 and top 400 systems have been threatened with having their children taken away from them. In the UK, police in London operate a database called the Gangs Matrix. This contains information and risk assessments on individuals who are alleged gang members. This database was created using criminal justice data, including police and crime records. Many of those involved are actually also victims of crime. The data that is included on this database includes people's full names, date of birth, their home address, their ethnicity, a risk assessment score that's been done about them, as well as police intelligence information. Almost 4,000 people are on this matrix, this database. The majority are under 24, and it includes children as young as 12. 78%, more than 3/4, are on the Gangs Matrix are black. The Gangs Matrix and the assessments it produces assists policing decisions, including the deployment of stop and search, and further enforcement action, such as imprisonment and deportation. A further tactic resulting from the Gangs Matrix is the threat of eviction, as information is shared with housing providers, and exclusion from education, as information is shared with schools and education authorities. So moving on to some of the data protection issues there. because these systems, these types of systems involved, are often partnerships or working relationships between both law enforcement and social services, it can be hard to decide whether which data protection framework applies, whether it's the General Data Protection Regulation or the Law Enforcement Directive. Of course, the GDPR applies to public authorities and private entities, except when the Law Enforcement Directive applies. But the current case law and literature, in my opinion, they don't provide sufficient clarity as to precise delineation between the GDPR and the Law Enforcement Directive in such partnerships. And these systems are operating on such huge data collection regimes by government, by law enforcement and criminal justice authorities and these social services. Data is coming from these multiple sources, including very sensitive personal data, health data, educational data, welfare data. There's wide data sharing between these authorities. Arguably there are multiple data protection breaches, purpose limitation, the fact that this health information, welfare information, educational data is being used ultimately for law enforcement purposes, data minimization. Can it really be adequate, relevant, and necessary to use this personal health and welfare data for law enforcement purposes? The excessive collection of all of this information and its retention for use in law enforcement action and purposes. This data is kept for years and sometimes longer. There doesn't appear to be any limit on how this information is kept, despite there obviously being clear limitations in the legislation. The question is, how can these actions, how can it be acceptable within the data protection framework? And if it is, then clearly the framework isn't working. There are known gaps. Article 22 of the GDPR and Article 11 of the Law Enforcement Directive, they talk about solely automated processing. But the fact is that there's a gray area here, that this automated processing is often not, it's not solely automated. There are humans in the loop, but there, as has been gone over many times, there's no meaningful engagement. There's no meaningful engagement by the individuals who are processing this data. I know that's a point that's been labored by many, and the European Data Protection Supervisor has said that there must be this meaningful engagement, so I won't labor it, but that's a kind of very short overview of, I think, some of the major data protection issues. But I'd like to finish by just saying that it's certainly not limited to these data protection issues. There are many major issues that are outside this framework. Data protection laws can regulate some of those problems, and that's if they're actually enforced, when they're often not. But many of these issues with these new technologies, these new predictive profiling systems, they're much, much bigger than data protection. The discrimination problems, for a start. The data that's used in these systems, it's involving these deep-rooted structural issues, the racism and discrimination ingrained in this data, which is used to make these predictions, profiles, and risk assessments. It's reflective of historical, systemic, and ingrained discrimination, which results in racialized people, communities, and geographic areas being over-policed and disproportionately surveilled, questioned, detained, and imprisoned across Europe and across much of the world. And these discriminatory practices are so fundamentally ingrained that all of these systems are going to reproduce these outcomes. The use of police intelligence, the use of hearsay, and I say, intelligence in these systems is another serious problem. These are value judgments, assumptions, often extremely biased, made by law enforcement officers on the street, and widely used as predictors in these systems. And often the number of police reports or the type of police reports about individuals is used as an indicator of criminality. So in that way, these value judgments are washed through these systems and then come out as effectively objective indicators of criminality. A second major issue is, outside of data protection, is the presumption of innocence. The fact is that these profiling, predictive, and risk assessment systems, they target individuals, groups, and locations, profiling them as criminal and resulting in this criminal justice action, including deprivations of liberty, before the actual actions have been carried out. It's all based on future actions. And in that way, these systems, by their very nature, they undermine the fundamental right to be presumed innocent.
Grave? Sorry. Do you think we can?
Yeah.
Thanks.
Just, and so finally, our view is that because of these major ingrained issues, the only way is to prohibit the use of these systems, to prohibit the use of predictive profiling and risk assessment systems. And that's something which we're working with the European Parliament and getting some support on and working very closely towards. There's lots to be said on the data protection stuff, but hopefully you'll ask that in the questions. Thanks very much.
Thank you very much. I found this example to be very striking. The two top 16 and top 400, top 600 and top 400 in the Netherlands. These are very appalling in terms of the very wide range of impact on fundamental rights. So thanks a lot for giving us this overview and these very concrete examples of the impact. Anna, would you like to say a few words about the Law Enforcement Directive, the legal framework? What applies to this type of technologies and what can be done, for bettering the enforcement of the legal requirements? Thank you.
Yes, thank you. First of all, good to see you all here, and I think it's an important topic, and I'm very glad that there's more and more people who actually come to those events. On the Law Enforcement Directive and how does it relate to technology used by the law enforcement? I think there are several things to say, but I will maybe start from what I consider to be the most important ones. There are articles in the Law Enforcement Directive that are very fundamental, including for the new technologies. And one of the most fundamental ones is not the one that comes first maybe to your mind, but it is actually a requirement to have an appropriate legal basis for processing. So Article 8 and Article 10 of the Law Enforcement Directive, which prescribe that the processing has to be based on law. That's one. There is a second part of this article which prescribes the minimum characteristic of the quality of that law. And why this is important? We know that one of the major issues or major principles of processing of personal data is that that processing has to be proportionate. So it's not an idea to prohibit, it's not the idea not to allow the law enforcement to use technology. The idea is to frame use of that technology by putting the condition, one of the most important conditions is proportionality. The assessment of proportionality starts with the good legal framework that allows for that processing. And I cannot stress it more. There is also Article 10, which also deals with the legal basis and the conditions for processing of sensitive data. And that Article 10 has to be read together with Article 8, that first of all, but Article 10 goes even further in a sense that it actually requires authorization in the law for the processing of personal data, unless there is data manifestly made public or unless there is a question of the vital interest. But the first condition that Article 10 puts, and the one that would most broadly apply in the context of law enforcement, is that there has to be law that actually authorizes the processing of sensitive data. That article also requires strict necessity assessment, and that article also requires appropriate safeguards. Appropriate safeguards that should be embodied already at the stage of the legislation. So again, the proportionality assessment is already undertaken at the stage of the legislation. Another article which was mentioned today is Article 11. That's the obvious article to discuss in the context of the new technologies. And that Article 11 also requires authorization by law for processing by automated means. So just to notice, we have Article 10 and Article 11. It also requires appropriate safeguards for that processing. And I would like to make first maybe general comment what I think about how the quality of law, regarding the quality of law authorizing processing. And the second, I will also give you maybe a little bit of how we see articles that I've mentioned actually transposed in the member states. So first, on this quality, we see the very explicit requirements under the Law Enforcement Directive regarding the quality of the legislation. So under Article 8, you have to have a purpose, you have to have descriptions of the types of data to be processed, the objective should be clear. That is also to be read together with Article 5, which directly requires the time limits for the processing to be set up. So you cannot read articles in separations with each other. And there is a clear requirement for appropriate safeguards. And I wanted to say that I think it's very important to take it very seriously. And I could not think about those requirements being met if processing I think that in order to meet the requirements of the articles, the legislator has to be in a position to actually consider risks, rights and freedoms of the persons concerned at the time of the legislation. This is where this proportionality assessment kicks in. So legislator at the time of authorization of that processing has to be aware of risks that the given technology brings. And I think this is also to say that it is important that legislation is not too general, that we do not fall back on the legislation that at the time of its adoption, the legislator could not, because the technology was not there, consider those risks. Very briefly, in terms of the transposition of those articles in the member states, I think overall conclusion is that those requirements are broadly transposed by the member states. So majority of the member states have included those provisions in their national transposition measures. So that's what we see, some of them in the quite literal manners, some with some modifications. What we do see, however, is that while across the board the principle is there, so in terms of Article 8, 10, 11, we see that some member states in some cases omit certain specific requirements that the Law Enforcement Directive puts forward, and in particular, the requirements of appropriate safeguards. And we do, that is things that is quite striking. Moving on, because time is ticking. Of course, the Law Enforcement Directive has the other provisions which are very relevant in the context of regulating and then application of the new technology. We all know about data protection impact assessment, and this is a tool for the data controllers to assess, to recognize, to name the risks and try to address those risks. We know about the requirements of data protection by design and data protection by default. And we also have a provision, which I think is very important provision in the context of the new technologies in particular, which is about the prior consultations of data protection authorities. So any processing that brings about the high risks to processing has to be consulted with data protection authority before that processing starts. And this is that the aim of that provision is to go forward with the processing, but have a second eye, to have an expert helping to make sure that the processing addresses the risks and takes into account the rights and freedom of the data subjects. I think I would also like to mention quickly that we have very recently had a guidance from EDPB about the facial recognition, which is, I think, the first guidance which was issued specifically in relation to technology used in the context of the law enforcement. That guidelines puts forward a general explanation on how to understand and how to read important articles of the Law Enforcement Directive, and it also puts forward scenarios. And I think it brings me again to the main point of the proportionality, because I think we all agree that assessment of that proportionality and the using of technology is very case specific. So it's a case-by-case assessment, and then if you change one parameter, you likely arrive at a different assessment of proportionality. I will stop here, but I'm happy to expand on those issues later on during the question session.
Thank you very much. I think it's very useful for this discussion to frame and to recall what are the legal requirements from the Law Enforcement Directive that should be implemented by law enforcement officers. So we will be looking at the guidance, and we're waiting, of course, for the publication of the first review of the Law Enforcement Directive by the European Commission. So we will be looking for that when it will be published. But moving on to this discussion, now I would like to turn to Julia from the Danish National Police and ask you concretely, how do you implement the Law Enforcement Directive in your day-to-day work? What is challenging? Thank you.
Yes, and I think first I have to come with a caveat. We're the Danish police, so I'm not going to talk about whatever the Dutch police might be doing or US police might be doing. Danish police does not do predictive profiling. Then I also want to just quickly answer some questions. Griff, it's good that I'm seated so far away from you, because no, law enforcement authorities are not interested in just having all kinds of big quantities of data. We are interested in the good data, because we have we have not the resources to sit and look at every individual to find the one criminal guy. You also said authorities want to predict criminal behavior. Yes, we would like to do that if it was possible, to protect you and everyone in this audience from crime if possible. Because, of course, we have to remember data protection, of course, is a fundamental right. I agree with the very foundations of this right. It is not an absolute right, and it stands along very other fundamental rights, for example, the right to physical integrity and not to be harmed. So that, I think, is just two things I wanted to say with regards to the guidelines from the EDPB. Very good inspiration. They've just been sent out to the public first hearing, and they haven't received our comments yet, so they're not law yet. So that was just like some of the comments that I wanted to make. The question, and also just to get quickly done over this, the first question that Elise asked, does the Law Enforcement Directive provide enough safeguards? Yes, I do think so. So let's go right to the challenges. So with regards to, I think this is heading towards more big data analysis, police forces wanting to use more data, so I'm not going into new investigative techniques like forensics. So I think here the Law Enforcement Directive and the aims of the Law Enforcement Directive are very well aligned what police forces are interested in. And that's also what I tell my police colleagues. You know, we are interested in good data quality, because law enforcement has been, we have very established criminal procedures already. If we don't have the right data quality, cases will not stand in court. That means we will have a waste of our energy. So yes, data quality, data integrity, that is very well aligned, and that is just our interest as well. I think some of the requirements that the Law Enforcement Directive just put into place or put into other wording were also known concepts before. Police has always also been under regulation with regards to information security. That means we also have to protect the information, like operative information, not necessarily always personal data. So these requirements of the Law Enforcement Directive fit very well into the general interest of the police. Some of the challenges, also what Griff mentioned with data bias or bias that is built into the systems, I completely agree. That is a big challenge. And AI systems, that's also why we, for example, in Denmark, are very reluctant to use this system. Because, of course, no serious police officer can have an interest in being biased in their work. Because if you're biased in your work, if you, for example, have a bias that you think that young, innocent looking women do not commit crimes, then you will not find criminal, young, innocent looking women committing crimes. So of course, you have an interest in that your methods are appropriate to find criminals, that you are not blinded by whatever bias, racial, gender, political you might have. So that is one of our interests as well. Now let's get into the challenges that we see in my daily work with the Law Enforcement Directive. One thing that is very dear to my heart is the challenge that we don't see it as a possibility to use data processors in third countries that are not considered as having an adequate level of protection. So for example, the US. We have digital crime, very specialized. We don't have the resources to solve all kinds of, or crack all kinds of encryptions, for example. So usually you would sometimes be dependent on private vendors, data processors that would help you with that. We don't see, when we read the Law Enforcement Directive, and specifically Article 39, if someone wants to nerd and write a PhD thesis about it, please, we don't see a possibility for us to use a data processor. We've raised this several times with the EU Commission. I don't see that it makes sense, because in the GDPR, it's possible. As Griff so finely highlighted, under the GDPR, you have the possibility to process sensitive data. You process health data under the GDPR, so it's possible to use private partners in third countries under the GDPR. Why shouldn't it be possible for law enforcement when you have the right safeguards in place? So that we see as a major obstacle in our work. Another example where we struggle a lot is that sometimes the concepts of the Law Enforcement Directive don't work with other concepts. So again, we think like data protection is the new bad word, but it's not. Like, some of these concepts have been there before, and data protection does not exist in a vacuum. The police has been regulated by criminal procedural law, for example, always. And some of these concepts, for example, access to data for data subjects, they do not fit with the concepts of data protection law. In criminal procedural law, at least in the Danish system and the German system, you always had a possibility to access files regarding to your case, but it's very highly regulated. So usually the access is only granted for the defendant and the victim of a crime. Jan Ellermann from Europol, he showed a very good example yesterday that, let's say I'm the criminal now, and then of course I do I'm involved in some violent criminal network, so of course the police has an arrest warrant and has a warrant to seize my phone. On my phone, then they look through it, and now I have to be careful that you don't see. But I'm not going to show you what's on my phone right now, but let's say then you see a picture of Julia with her criminal friend. In the background, you have some unrelated person. If you zoom in, you can't really see the face, it's a little bit blurry, but yes, maybe some person that knows this person in the background could identify, so ergo personal data. Well, in criminal procedural law, you always had very well established that this by person, as we would call it, would not have access to data, because this is part of a criminal procedure. An ongoing criminal procedure, you cannot have access to this data. Would that person then have access to the data under data protection law? We don't know. And it's a very nerdy question, and it usually doesn't pop up in these panels because it's not as sexy as profiling and algorithmic intelligence and me standing in front of a wall and painting networks. But this is very real, and this is like what my daily life actually looks like in data protection. Also, data subject access rights. I wish sometimes that we could do all the things that the public thinks we are doing, but the reality, even in Denmark, digital society, a lot of we went into an electronic case, administrative case system. We got that 3 years ago. So basically, when I have to have access to a file, people come carrying around moving boxes with paper files. This is the reality, and And I have a data subject access request, so basically I have to ask, ring to the archive, is there some file where that name comes up, and then we have to manually go through the files, just to come to the conclusion, if it's a criminal ongoing procedure, well, we can't give you access to the material anyways. Does that make sense? Well, let's say it like that. I would rather spend my time building IT systems that prevent discriminatory bias, that make data secure, that ensure data quality. So that is just like some of these challenges that we work with. Also for some of you who attended the amazing Europol panel earlier this day about what the French police was doing on Fortnite with an avatar. I am positively convinced that this would not be possible in Germany, because then you have questions of joint data controllership, all these things. And that's where I feel we need to talk about the concrete cases. I agree, maybe that you shouldn't deploy huge surveillance systems to investigate bike theft in Copenhagen, which is very irritating, but the harm, of course, is limited. But maybe we have to talk more seriously that you have to accept some infringements on data protection rights to protect very vulnerable groups from a very concrete infringements of their right to physical integrity. And we need to have this open discussion, and we need to move it away from the abstract and move it into the concrete, like we were doing today at the Europol level. We need to talk about what is at stake in this system. And that, of course, is where the Law Enforcement Directive comes in and asks for proportionality. But we need to be honest and open and say, yes, proportionality means that we live with some infringements of data protection rights to protect some rights that we as society deem more protectable or more important in this concrete case. And we cannot have these discussions on these very, very abstract terms anymore. We need to move down. We need to look at the French example and say, this avatar, can we use it now in this case? Can we use data retention of telecommunications data? Can we use it in this case? Can we use AI in these specific cases? So I don't want to have these discussions anymore. Can the police use predictive profiling? I want to have this discussion. Can we use predictive profiling to prevent robberies? Can we use predictive profiling to prevent child abuse? So we need to come down to the individual case level.
Well, thank you very much for giving us a law enforcement perspective in this panel. I think it was...
Just fake law enforcement, because I'm a lawyer. I only have a very unhealthy interest and a husband who's a police officer. So take that with some reservations.
So the DPO law enforcement perspective on this panel, it's quite interesting to see what are your challenges in applying the different requirements, and also, the different type of understanding that one can have on purpose limitation and data minimization. So I'm sure that there will be a continuation on this. So now I'm turning to you, Juraj. So you will have the very difficult task of trying to find the right balance between the legitimate interest of policing and the mandatory protection of fundamental rights and data protection. So what are your views on this? Because I know that you've been researching this and you've been publishing about this. Thanks.
Thank you. Thank you very much for the opportunity to speak on this panel. As the last speaker of the day, actually, not only of this panel, I will end on a very conciliatory note. All is good. Everyone just calm down. Everything is good with the LED and the technology-led policing or use of modern technologies. So I'm not going to reply to other panelists, even though it's itching, but I'm going to stick to my presentation, which is really about the research that I've been doing for the last 2.5 years. And we were actually looking at exactly these issues, but in the academic context. So you would understand that the level of abstraction in an academic context will be significant, and that maybe I won't be concrete enough, but we can speak about concrete cases in the Q&A session. What we learned in our research project that, as I said, started 2.5 years ago, we've done a lot of empirical research, especially here in Benelux countries, We met a lot of stakeholders that are involved somewhat with the LED, so either practitioners, police officers, investigative judges, prosecutors, defense lawyers, PIU units, FIUs. So we spoke a lot with practitioners, but also with the people who are worried about victims' rights or data protection community as such. And we have basically faced two concerns or two questions from two different camps. From the law enforcement community, we were often hearing about their concerns, or they're wondering whether the LED, as transposed in national laws, is flexible enough in order not to interfere with the efficient progress of criminal investigations and criminal proceedings. And on the other hand, from the data protection community and stakeholders involved in that community, we heard more questions like Griff was raising, whether the LED is an instrument that is of enough quality to ensure a comprehensive and high enough level of data protection or any other fundamental right protection. So what I want to demonstrate here is that the use of technology, modern technology by the law enforcement authorities are regulated in a LED in a way that strikes that delicate balance between the competing interests. Professor Skoll, Mark Hall, and Professor Paul de Heert and I, in our research project, analyzed the LED in detail, and our finding that I just presented is supported with a closer look at the two fundamental principles on which the LED is constructed, which is the purpose limitation principle and the data minimization principle. When we look at the academic literature about the purpose limitation principles in the LED, there are a lot of concerns about how weak it is, allegedly, and how there is alleged legal unclarity on data flows between private actors and the law enforcement. We do not share those concerns at all, because we think the right balance was struck by an odd, maybe even aleatory combination of old and new. Because if you look at the LED, there are some old wording, old principles derived back from instruments that are like 40 years old, like the Convention 108 or Recommendations 8715 of the Council of Europe for the police sector, then the Framework Decision 2008, that was the predecessor of the LED, even Regulation 45/2001, the old regulation for union institutions and bodies. That is combined with the new constructions that were made for the GDPR and then sort of transposed or taken over by the LED. So if someone is saying today that it's difficult to square purpose limitation or even a mere purpose specification obligation and data minimization with modern technologies, in the case of law enforcement, the LED has done some adjustments without ruining the core of the principles. And why? Because the negotiations on the LED were very intensive, in particular in 2015. And both the police and the data protection specialists and the prosecutors were present at the negotiation table. So the directive had to be already mindful of the technologies and willing to adapt data protection obligations of law enforcement authorities. If you look at the purpose limitation principle, the LED constructs it in a very different way than the GDPR. Not through the notion of further processing, but through the specific rules on the change of purpose. And this is even not a novelty in EU law, because that concept can be found in the Regulation 45/2001, now defunct, that I mentioned. That was, coincidentally or not, another instrument which had a narrow scope and which was designed only for public authorities. And what I'm saying, you will find in Article 4, Paragraph 2 of the LED, because it speaks about the change of purpose in a way that there is, what is possible is subsequent processing by the same or another controller. It's permitted if it's authorized by law and if necessary and proportionate to that new purpose, as long as the new purpose remains within the scope of the directive. So every subsequent use of data that enters the LED realm by the police or other controllers within the scope of the LED, such as prosecutors or criminal courts, is then specifically covered by that provision, Article 4, Paragraph 2, And you, of course, couple it with a compatible use building block of the purpose limitation principle that is always there in Article 4, Paragraph 1, Litera B. So I find that the LED's architecture of the principle allows law enforcement authorities to collect and process personal data from several legally available sources without facing the excessive red tape. They can access the data that was originally collected by other actors, like private companies. They can collect data themselves from multiple sources or open source. They can carry out any other processing operation under the LED as long as Anna said, is based on law. And the second novelty that LED introduces here are provisions on data transmissions of operational law enforcement data from competent authorities to other authorities or private parties within the EU. That's Article 9, Paragraph 1 and 2. So we can call those paragraphs launchpad provisions because they regulate data transmissions from the LED realm to the GDPR realm. And Article 9.1 provides that the GDPR applies to subsequent processing of personal data originally collected under the directive when the data leaves the scope of the directive. And then there is a safeguard provided that you have to have union or member state law allowing that. And it also makes clear that law enforcement authorities may have other tasks that are not covered by the LED scope, in which case they have to apply the GDPR for processing of personal data, right? So those provisions show that the directive is opening the door for transmitting operational data to private recipients, such as joint controllers in public-private partnerships, and other public actors that are not law enforcement authorities, like customs authorities or tax authorities. It even allows the same authority to launch the data outside of the LED and process it under the GDPR for some non-law enforcement purpose, the simple one, archiving, right? So if you speak about modern technologies, remember the 3 V's of big data: variety, velocity, volume. What I just told you, you already have 2 V's there. You have the variety and the velocity. You have use of data from variety of sources and easy sharing and repurposing of data. But on the other hand, only to a reasonable extent. So you cannot do arbitrary data collection without legal basis. You cannot introduce obscure, unspecified purposes of data processing. You cannot cooperate with private companies who are clearly violating the GDPR, like in the Clearview AI case. And so we wrote this in a paper that we published as a Brussels Privacy Hub working paper in December. But if you don't believe me, you can read the opinion of Advocate General Sanchez Bordona that was issued on 19 May 2022, so last week, case number C-18021, and I think it confirms what I just said. So that's the purpose limitation principle. If you look at the data minimization principle, compared to the GDPR, it implies a much easier burden of proof for the controller. There is no need in the LED to limit yourself to the minimum of what is necessary. Because of the use of the old language, the old illegal instrument that we're speaking about, not excessive use. So you can operate with less provision, you just need to make sure not to process excessive data sets. And that's where you have the third V, variety, velocity, volume. Here you have the volume. So in a nutshell, LED facilitates law enforcement data collection and subsequent processing imminent to the law enforcement use of new technologies, at the same time preventing law enforcement authorities engaging in collection of personal data just in case, processing personal data just in case, or engaging in some forms of mass surveillance. Right? Is the LED then ensuring that the adequate protection of human rights in this context of law enforcement use of new technologies? Maybe not, but I'm not sure it's its job. Yeah, I think the job of the LED is to make sure that the personal data protection is, or from Article 8 of the Charter of Fundamental Rights, is adequately protected in a case when law enforcement authorities process personal data for law enforcement purposes. So we cannot complain about data protection laws that are being too omnipresent, regulating everything, and on the other hand say that they have shortcomings because they don't protect all fundamental rights. So I think there is a discrepancy there. what we need to look into in the future is interplay with other areas of law, definitely. In particular, in this case, the criminal procedural law. I don't think there's enough dialogue there, and maybe an idea for further research to look into how the EPPO is working, because it has this peculiar structure where it applies the basically copy-paste of LED for its processing of personal data, and then has to apply national criminal procedural law, has this hybrid structure, EU national double hat, so it's maybe an interesting case to look at. And then the problems that we should also speak about and look more into are about the supervision of the LED. So we started that last year in CPDP. The discrepancies between member states and what their data protection authorities can do in the LED realm are enormous. You know, you have the German DPAs who cannot even impose a ban on processing, and the Commission just launched infringement proceedings against Germany for not having effective corrective powers for DPAs in the LED realm, to the Dutch DPA that can issue the same administrative fines like under the GDPR. So there are some concrete actions against law enforcement authorities, like I mentioned already, Clearview AI. You had in Belgium, Sweden, Finland, fines against the law enforcement authorities, like in Sweden, even 2.5 million kronas. But yeah, definitely an area where I think the DPAs are still not doing enough. So thank you very much.
So thank you very much for this. I think that you made the point that the Law Enforcement Directive provide enough safeguards in order to protect individuals when new technologies are used by law enforcement. So the key question would be how to make sure that it is properly enforced, properly implemented. But we have a few minutes for questions, and as I said, unfortunately we began a bit late, but I would be very happy to have questions from the audience. So I see a hand over there.
Hello, everyone. Thank you for the panel. I'm Irmak Erdoğan, a legal researcher from Istanbul. I have a quick question regarding profiling. When it comes to group profiling or the profiling of neighborhoods to decide where is the next crime going to be committed, do you think that Article 11 falls short because it requires a decision to be taken based on profiling, but in most of the cases, just when you decide a neighborhood is dangerous, there is not necessarily a decision regarding one person. So how can we include this part, not to wait till the end that a decision is taken about the person? Secondly, the same article also requires that prohibition of profiling when it causes discrimination. How should we interpret the discrimination nowadays? Because it's not only based on gender or race, because as Griff mentioned, it takes data into account, like if you change schools a lot, if you don't get along with your teacher, which might be a sign of intelligence actually, but still it's like all this kind of data actually tells like a normative person, like how we should be. So is it a new form of discrimination deciding who is normal, who is not, and how can be integrated into law enforcement context?
Thank you. Is your question targeting one of the panelists, or should we invite all of them to reply?
All of them.
Thank you. So maybe, Griff, do you want to begin by saying what is your view on these specific questions? Because it relates also to what you were talking about in terms of predictive policing, profiling.
Yeah, sure. Thank you. I think I can probably only speak to the second one that you asked. And I think one of the fundamental problems with, whilst the letter of the law should prevent discriminatory profiling, the fact is, and I think that speaks to a general problem with the regulations, both of them, is that whilst they may say lots of good things on the face of it, it's how they're actually operated in practice. You know, there's lots of good points made, but the fact is that they're not always being enforced in practice. It's how they're operated in practice. It's how law enforcement and criminal justice authorities, how much attention they pay to them. And particularly on the profiling point, the fact is that there's different conceptions of what profiling means. And I don't mean in terms of sort of ethnic profiling versus profiling in the data sense. I mean in the fact that across Europe, the concept of ethnic profiling is actually accepted and practiced by law enforcement authorities, and that's a fundamental problem. There's been legal cases in which ethnic profiling of individuals for police control is an accepted part. It's an accepted strategy of law enforcement. In other countries, it's not an accepted strategy, but it's something that happens nonetheless. So whilst the letter of the law says that shouldn't be happening, the fact is that in reality it is, and it's very widespread.
Thank you very much. I can see that already both Julia and Anna wants to speak.
Yes, but because I think I would like to invite Griff to Denmark, because either we're like completely odd, or I don't know, because no, we're not ethnic profiling as I define it. If we define as I understand ethnic profiling, to go after certain ethnic groups to stop and search, it's not an accepted practice in the Danish police. We're not interested in that. So just to make just to say that, because I truly reject this statement. With regards to the question of neighborhoods, super interesting question also, like when are we into the sphere of personal data? And I think we should also break it down what is done there, like when would we use predictive policing techniques with regards to neighborhoods. Griff's organization, you presented some examples from Germany where you would use predictive policing techniques to predict whether burglaries happen in a neighborhood, because there's some studies that show that if there's a burglary in one house, then the chances are quite high that there's going to be another burglary in the neighborhood in a certain amount of time. Again, here I would say data protection law is not in a vacuum. So the decision, if we would take it in the Danish police, it would not be purely automatically that something is just being spat out, because it would be part of like an operative plan. And for these operative plans, you have to decide where do I deploy patrol cars, where do I deploy my personnel. So that would be one part that would inform your general strategy. So sometimes I think exactly with these kind of examples, we have to look what is happening and how do these profiling or algorithms feed into the larger organization that the police also is. It depends what kind of, like that again is where data protection law gets super interesting and nerdy and tricky. Would I define a neighborhood as personal data? Not always. Let me give you one example from our. Sorry. No, I can't give you any more examples because I have to leave afterwards. But
thank you very much for clarifying this. Just would like to invite Anna just to say maybe just in one sentence or two, because we have another question and 6 minutes before the end of the panel. Thanks.
Okay, very difficult task. There are two things that I heard, and I maybe will start from the reaction and to the enforcement issue, which is in fact the second sort of pillar of our panel. So enforcement is very important, and indeed in order to, let's say, make full use of the Law Enforcement Directive, we have to have it enforced, and we have to have it properly applied in the law enforcement authorities. On the enforcement, this is also in the Commission that we saw that the question of the status and empowerment of the data protection authorities are very crucial. This is why we have launched the infringement very recently against Germany regarding the corrective powers, or the lack of the corrective powers. There are other infringements that have been launched a month earlier against some other member states on the crucial aspects of the Law Enforcement Directive, including Article 8, including Article 10, including Article 11 that I've mentioned today. and these issues remain very central to us. In terms of the enforcement, I think it's also very important to speak about the culture of compliance, and that we should have a good culture of compliance. And here, I mean, a big topic again, we don't have time, I will not elaborate, but I think the status and the functions of the data protection officers are very important as well. So the data protection officers should be the one to advocate actually data protection rights, not engaging into the policy work that sometimes might happen. I think it's very important that they are properly funded, that they are properly trained, and I would very much wish to see that there is a good cooperation and the dialogue with the data protection authorities, because I think this would be the good way of sorting out a number of problems. And now coming back to the first question, which is around profiling, again, the big topic. Again, I wanted to come back to something that I said, that I think we should look at the Data Protection Directive holistically and together. So we do have a general requirement of purpose specifications, proportionality and necessity. And when making that proportionality and necessity assessment, one has take into account the rights and interest of the persons concerned, generally speaking. So I think also in terms of the discrimination, I understand the discussion around the ground of discrimination. Again, I think when we, often at times when we deal with the discrimination, we would also deal with the legal effect to a person. So I would invite you to lead the Law Enforcement Directive holistically and try to use the means that it provides. I will stop here.
Thank you. We can move on to the next. Okay, so maybe it will be for you. Please.
Okay, let's see. Okay, the mic works. I'm Hartmut Aden from Berlin School of Economics and Law. Thanks for these very interesting contributions, and what you have said regarding the Law Enforcement Directive partly overlaps with what we have seen in our research regarding this directive, that, let's say, many member states have probably, including Germany, have implemented it in a very formal way into their domestic law. But there is not so much evidence that this is really something that has led to a practice. So, for example, data breach notification, does this really take place? For example, impact assessment, do law enforcement agencies really do that? So probably transparency might be some kind of first step in order to generate more knowledge on that and to see if there is a practice. So I think that would be probably something in order to make this something that is more than just paper.
Thank you very much. Yeah, another question, please.
I'm Henrietta. I just wanted to make a correction to the Danish police about profiling and maybe racism or anything on that level. There was an EU media survey done in 2019 where Denmark was also responded. It's called Black in Europe. There are statistics there that are not congruent with what you were saying. There's also the case from 2019 where with the telecom data and the Danish police, where the report that was done by Deloitte. It also is not very congruent with your stand. Griff, I just wanted to say I thank you for your stand and for all the digital activists, because I'm a practitioner, but as you can see, but I'm also Black. Some of these things are not theoretical to me. A question I want to ask you is, since the UK has more language, I feel, when it comes to discrimination, specifically systemic racism, what role does it play in the discussions that I often hear in Brussels, where there's a neutral person and everybody believes in saying racism, it almost points back at them. But in the end, it's harmful because you cannot have AI without that language. Thanks.
Thank you very much for this. First question, very much related to what we were talking about in terms of the importance of enforcement. Do you want to reply to this, Yura?
Okay, very briefly, because we have 37 seconds left. Yeah, about the practice, and Well, our research, as I said, is based in Benelux, but we were looking at other member states as well. The practice in Benelux is changing drastically ever since the LED entered into force. It really is a game changer in the law enforcement community. And of course, in other countries, the situation might be different, but I think other EU member states, but I think it largely depends on several factors. One is how does the data protection law that transposes the directive interacts with other sectoral laws that apply to the law enforcement authorities? Are there any other carve-outs or workarounds and things like that that make it then just something on paper or not? And the other factor is how serious is the data protection authority about the supervision and enforcement of the LED, or it's a data protection authority that doesn't have time for this or the powers to do this.
Thank you for this, and please, Julia, do you want to reply to the last question?
Yes, there was one question about personal data breaches, whether they are reported. I think that's one of those, I mean, there's public access to information. I think you can get all the numbers there from the data protection authorities. I can tell you from the Danish perspective, yes, I do that every day. I find it very, very tiring. One comment from the audience with regards to one telecommunications scandal. Yes, you can read it all up. In 2019, we had a big scandal that we uncovered ourselves in the Danish police and that we brought to the attention of the public itself. And yes, that is one of the reasons why we think that data integrity is really important. Do I say that everything is that we're 100% compliance in the Danish police? No. If anyone tells you that they're 100% compliance with LED or GDPR, do not trust them, because I'm sure they're not. So no, it's a journey. And with new techniques, there's new challenges. And we're trying to just do our best, because ultimately we serve the citizens, every citizen, I would like to highlight, irrespective of gender, ethnicity, or whatever orientation.
Thank you very much for this. I think we can safely conclude, but I see, Griff, you wanted to add one last. If you still have 5 minutes, then thanks.
Just very quickly to respond to the last question that was asked there, and I think it is worth echoing, and thanks for making that point. But on the data point, it really isn't an open question. In every European country where data is collected, and the Fundamental Rights Agency has actually done 2 good studies on this in 2010 and 2018, looking at policing and its impact on people from racialized backgrounds. But in every European country where data has been collected and analyzed, black and brown people, people from racialized backgrounds, Roma, are overrepresented in every metric: arrest, pre-trial detention, conviction, sentencing, disproportionately more so than white people. And that is the data that's being used. You know, whatever the framework may say, however well it's implemented, the fact is that's the underlying data. There are some countries where there isn't any data collected, and unfortunately that means that discrimination is happening in the dark, but that is unfortunately a factual reality, and it seems to unfortunately bear echoing repeatedly and repeatedly because people don't seem to be getting it. But that's the reality, and that's the framework, the society within which we're living, and there's only so much that data protection can do about that.
Thank you very much for this. So thank you. One last sentence just to say that I think we can, from everything that has been said, we have the legal safeguards, they are there, but they just need more guidance and harmonization to be effectively implemented. So thank you very much for joining us. Thank you for attending this panel, and enjoy the Brussels evening. Thanks, bye.